Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you with my pearl handle pistol cufflinks given to me by my proud content genius son, Michael Rivers. He's responsible for all this content. I just work here, man. Today we're going to talk a little bit about rap lyrics being used in criminal trial. Rappers are feeling targeted. But before we get to that, guess what? This episode is brought to you by eSign.com. eSign.com. Let's say you've got some fly lyrics and you are sitting in your basement and you can't get out because you got COVID. And the record label says you got to sign this today, otherwise, we're going to give this $10 million to somebody else. Well, you go to eSign.com, you download the app, and you sign the contract remotely. You get 3 signatures a month for free, and it's fantastic. It's a good way to get business done in a quick way. You can do it remote, so that's why we use eSign.com. I use it all the time on retainer agreements, so you can use it for any kind of agreement. eSign.com. Follow the link down below, get the app, and you'll see that it is the efficient way to do business. Now, we're going to talk a little bit today about Young Thug, who's on trial for the RICO case and a homicide that's embedded within that. One of the things that people are complaining about is that they think it's a violation of your First Amendment rights to include rap lyrics in songs, and it really has a chilling effect on creators. They're also saying that it is an unfair targeting of African Americans, and that there really is a double standard when it comes to other artists. Let's talk about the double standard for a second. If Willie Nelson, for example, sang about killing Johnny Cash, and you can match that up to him killing Johnny Cash, well, you know what? Those lyrics would be used in court. It's called self-snitching. But I agree, and in fact, I've successfully defended on my last homicide that I tried. I successfully defended keeping rap lyrics out of court. And the reason why this was a case where my client had created a rap video, and it was kind of a drill type video. And when he did this video, he's talking about, how he would respond to guns on the street. Well, what is that? What kind of evidence is that? That's bad character evidence. It's called 404. You cannot offer bad character evidence of the accused in a criminal trial first. So to the extent that it is bad character evidence, you can't do it. And that's how I was successful in keeping that out. Generally speaking, you can have character evidence of anybody or of a particular pertinent trait of the defendant, as offered by the defense. The only time you can offer evidence of character of the accused when you're a prosecutor is to rebut any kind of positive. So if I say Mr. Williams is a good family man, he's a good this kind of guy, you put all that stuff out there, then the prosecutor can use bad character evidence, and that's kind of what these rap songs are. However, there's another rule that kind of takes the place of the rule I just told you about. So when you look at the rules of evidence, are the filter through which things come into court, right? And so when you have a statement of a party opponent, you got the state, you got Mr. Williams. So Mr. Williams is the party opponent. So if the state has a statement of the party opponent, they can use that against him if it's relevant and material. So it has to have some relationship. It can't just be that you can use any statement from anybody at any time. However, it's liberally applied. So if Mr. Williams had said, I rented that car, you know where you are, blah, 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 and he had some rap song about the specifics of that car, the prosecutor in Fulton County is going to try to get that in. Now, there's been some legislation, specifically in California, to try to keep these rap lyrics limited. And this is almost the exact test that I used when I successfully defended that murder case and keeping the rap lyrics out. So in any criminal proceeding where a party seeks to admit as evidence a form of creative expression, The court, while balancing the probative value of that evidence against the substantial danger of undue prejudice under Section 352, shall consider, in addition to all the other factors. So in most evidence, probative versus prejudicial. That's what you look at. Is this evidence going to lead to some facts that shed light on the entire case? Or is it so prejudicial that people are going to get confused, they'll be inflamed, that it's just bad character evidence? The statute tells you to look at the probative value of such expression for its literal truth or as truthful narrative is minimal unless expression is created near in time to the charged crime. So if it's created near in time, in my case, it was about 1.5 years before the homicide took place. So if it's created near in time, bears sufficient level of similarity to the crime or crimes charged, so it's got to be talking kind of about what the charges are, or includes factual detail not otherwise publicly available, in other words, self-snitching, and undue prejudice includes, but is not limited to, the possibility that the trier of fact will, in violation of Section 1101, treat the expression as evidence of the defendant's propensity for violence. Can't do that. Or general criminal disposition, as well as the possibility that the evidence will explicitly or implicitly inject racial bias into the proceedings. Let's break that down a little bit. So the intent of the legislation is to provide a framework by which courts can ensure that the use of an accused person's creative expression will not be used to introduce stereotypes or activate bias against the defendant, nor as character or propensity evidence, and to recognize that the rap lyrics and other creative expression or circumstantial evidence or motive of intent is not sufficient justification to overcome substantial evidence. In other words, got lily white housewives sitting on this jury, just using an example, and they don't listen to drill. And if all of a sudden you put this stuff in front of them, are they going to be so biased because of stereotypes or racial bias, or just so freaked out by the violence that's displayed that they're going to say, oh, this is, that if he did it in his video, he's talking about really what he is likely to do on the street. It's called propensity evidence. That's inadmissible. You cannot use evidence to show that somebody acted in conformity therewith. In other words, just because they talked about it doesn't mean that you can use that now to show that they're likely to have done it because they talked about it. However, if it's close in time and there are specific factual details that are talking about what really happened.
Got kidnapped, they found his bones, he was right. Where's Corbin?
Where is Corbin Johnson?
Corbin ass was lost until they found him in that bag. No.
Corbin Johnson was last seen alive in July of last year. Then last Friday, a man discovered the victim's skeletal remains.
And that was created like right then and there. Then it probably comes in. But if it's so overwhelmingly prejudicial that, and that was my argument, because mine wasn't created close in time, and it was so over the top that it was just, a jury could convict just based upon him being a bad guy. And the prosecutor can't go forward with saying, oh, he's a bad guy, so therefore convict. Can't do it. It would get reversed in a minute. When you're talking about out-of-court statements generally are hearsay unless they fall within an exception. So hearsay is a statement by a declarant out of court offered for what? For its truth. Okay, so that is the definition of hearsay. Now, when you have these rap lyrics, one could argue they're not offered for their truth. Well, then let's stipulate they're false. So hearsay is a statement by a declarant offered for its truth. It's an out-of-court statement, basically. Basically, a declarant is somebody who's going to be testifying in court. So, for example, I have a trial. I'm on trial for manslaughter. Let's say I ran over a child being drunk. And my son makes a statement out of court, but he's not available for trial. So his statement, whatever he said, oh, he did it, he pointing at me. He did it. And so they can't reach Michael because Michael's dodging a subpoena. And so they try to get that statement into court. Well, it can't come into court because it's an out-of-court statement. It's not under oath. It doesn't have sufficient indicia of reliability. That's kind of the catch-all phrase that we use in legalese. So Michael has to testify that he said that, otherwise it's hearsay, so he can't testify. The rap lyrics, the rap videos and the lyrics, they're powerful. It's theater. It's absolutely theater, right? But when they're talking about real events, and I think that's what this prosecutor was talking about. This prosecutor, Fannie Willis, the Fulton County prosecutor in the Thug case and other cases. I'll read you some of her quotes here. "I think if you decide to admit your crimes over a beat, I'm going to use it," Willis told reporters at a conference. "I'm going to continue to do that. People can continue to be angry about it. I have some legal advice. Don't confess to crimes on rap lyrics if you don't want them used, or at least get out of my county. You don't get to commit crimes in my county and then decide to brag on it." And that's what these things really are in some respects, because nothing happens if it's not posted on the internet. It didn't happen, right? You do not get to commit crimes in my county and then decide to brag on it, which you do as a form of intimidation, not be held responsible. So, like these diss tracks, going back and forth that you see, they are a form of communication, not just a form of music. They are a form of intimidation to show. They talk about ops, they talk about dead ops, they talk about stepping on people's graves and smoking on their ops. When you see these very, very callous and cold, they're really cold tracks. They can be used, but it has to be judicially looked at. I read you the statute in California. California does not, it just sets a framework up on how they're to be used. They're not saying that you can't use them as a prosecutor. So it's always a balancing test, right? So prejudicial versus probative. But is there a double standard? I don't think there's a double standard because there's nothing else to compare it to. Is Mariah Carey, are they going to use Mariah Carey's lyrics against her? No, of course not. Why not? Because she talks about Christmas and whatever the fuck she talks about. There is no equivalent to the rap lyric, and it's really not all rap lyrics. It's primarily drill. Let's just keep that clear. It's primarily drill, and really a good lawyer should be able to keep it out because it is art. Unless it's talking about real events and talking about, you heard the judge, and I think we played that for you before, but, the judge read in the jury selection Thug's own words.
"Hey, this is that slime shit. Hey, YSL shit. Hey, killing 12 shit. Hey, fuck a jail shit. Hey, cooking white brick."
But he's reading this stuff, and I don't know if they tried to litigate that ahead of time, but the actual songs themselves, the prosecutor was using in the indictment itself as an act in furtherance of their conspiracy. So one of the things, when you're doing jury selection, they read you the charges. And, there's 60 or 70 counts in that indictment. That should have been litigated ahead of time because, and maybe it was. I don't know if it was or not, but I would have filed a motion saying, look, they put this in their complaint. They put this in one of their acts in furtherance of the conspiracy. But we think it's so prejudicial. Fuck the judge. That was one of the lines. Fuck the judge. How is that statement a statement in furtherance of the conspiracy? They're talking about the legal system. They're talking, to me, it's just so much more prejudicial than probative. And some of the other things that they talked about when he actually made those statements in court. When you have their attention and you're spitting those words out, they're hard to ignore, right? They're absolutely hard to ignore. I'm a defense lawyer, and I'm probably one of the few lawyers out there who've actually litigated this issue. And I argue hard to keep those lyrics out because they are so prejudicial. And it is art. And if it's not talking about a specific crime, all it is what? Propensity evidence. Trying to show that my client acted in conforming with some other prior behavior. You can't do that. A prosecutor can't do that. Let's just, if you talk about something else, like some other act the person does, and it has nothing to do with the case, the only purpose for that act, whether it's a song or whether it's an act that he did, it's just to show that he's done it before, so he's going to do it again. And that's just propensity evidence, and it's highly prejudicial, more prejudicial than probative, and that's kind of the standard. So look to that. I like the statute in California because the California sets up some guardrails so it doesn't have such a chilling effect on a creator, an artist. So this is just our 2 cents worth, just give you kind of a legal framework on the issue of rap lyrics going into a criminal trial. So I'm Bruce Rivers. Make sure you sign up for Patreon. Follow us on Instagram. Follow us on Twitter. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, police is at my god.